Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and we're continuing to study shareholder litigation. Last time we explored discovery. That's the phase where you gather evidence to prove your claims, building on the pleading standards we covered before. Now we're going to focus on pretrial motions. Pretrial motions are strategic tools that challenge or resolve parts of a case before going to trial. And these motions test whether a suit has the strength to proceed. They can often decide outcomes early and play a key role in reducing agency costs. How? By filtering out weak claims. We ensure only serious misalignments between managers as agents and shareholders as principals consume court time. We'll cover the main types of pretrial motions today, and we'll do a deep dive into summary judgment, which is perhaps the most important pretrial motion. And we'll connect this all to substantive law for both direct and derivative actions. Pretrial motions are requests for a judge to rule on a specific issue, like whether the case should continue or if certain claims can be decided without a full trial. In shareholder litigation, they're essentially efficient mechanisms that prevents dragging everyone through a long process that the facts or law are clear. This allows early resolution instead of a full trial to debate things that aren't really debatable. The two primary ones are motion to dismiss and motion for summary judgment. Motions to dismiss happen early, and they test if the complaint meets the pleading standards we discussed before. If a complaint doesn't meet the pleading standards because, for example, it lacks specific facts, the case ends before discovery ramps up. Summary judgment comes later, after the evidence is gathered, and it asks the judge to rule when there's no genuine dispute of material facts. These motions enforce substantive corporate law. In direct actions, they check securities rules like fraud claims, and in derivative actions, they verify fiduciary breaches under DGCL and MBCA. Let's start with the motion to dismiss, which directly builds on pleading standards. As a reminder, we covered pleading standards in a previous episode, and we learned that federal courts require plausible complaints with particular facts under the standards of Twombly and Iqbal in federal court for direct action. Delaware likewise demands specificity to show demand futility. So we have to plead with specificity. And a motion to dismiss will argue that the complaint falls short of this, that there's either no real claim, or there's an improper jurisdiction or improper venue, or that we haven't pled the facts with particularity. For a direct securities fraud under, for example, Rule 10b-5, a defense might say that there's no intention, no scienter shown, or there's a lack of materiality, or this complaint doesn't show causation. Of course, we can respond by pointing to pleaded facts like misleading statements and losses. And then we may have a hearing where the judge will either agree or disagree whether the claim is vague and dismissed or valid and continue. Likewise, in a derivative litigation, the challenge is often around whether demand futility was real, whether or not the directors really were conflicted out. You have to detail director benefits or ties, or out goes the claim. These motions tie to substantive law, proving a breach of loyalty, like self-dealing, or breach of care, like oversight failures, again requires showing facts that an agent's misconduct harmed principals. Now, moving to summary judgment, we've moved way beyond pleading standards, and we have a lot of facts because we are now talking about having either some or all of extensive discovery completed. And what we're trying to avoid is the cost of actual trial. This is where evidence shines through. One side is going to say the facts are undisputed and we win as a matter of law. To defeat a summary judgment claim, the other side can either say, no, the facts are disputed and we need a fact finder to determine them, or even if undisputed, that doesn't mean you win. So there are different ways to approach this. Once again, this is not a full-blown class on civil procedure, but shareholder litigation is one specific type of civil procedure here. So as a reminder, there are two types: full summary judgment, which would end the whole case, and partial summary judgment, which would resolve a specific claim. So in a direct action, we might target an element like causation and say, the facts show the misstatement didn't cause the loss. And if that's true, if the facts show that the misstatement didn't cause the loss, or that there was other variables that caused the loss, or that the shareholder did not hold the stock during the relevant period after discovery, then the case can be resolved on summary judgment as a matter of law. The counter, of course, would be evidence that's discovered, like trading records showing the opposite, or showing that the stock was held, or showing that through regression analysis and expert testimony, there is evidence that this statement actually caused the loss and it wasn't some spurious thing like a new tariff that changed the economics at the time. If there's no genuine dispute, if the facts are truly one sided enough, the judge can rule without trial. In derivative cases, we might test fiduciary claims after the Special Litigation Committee makes its report. So the Special Litigation Committee is going to be really important evidence that will only come up because we're not going to form a Special Litigation Committee unless the board agrees to proceed with litigation or if a shareholder is successful in proving demand futility. So the Special Litigation Committee's report is its own piece of crucial evidence that determines whether or not the board breached its fiduciary duties to the corporation. If the evidence shows disputed facts on a duty violation, then summary judgment should be denied, which again means that we're going to move to a full trial where a finder of fact is going to have to make the decision. Forum and technology influence both of these motions. Federal courts grant more summary judgments in direct suits due to more stringent standards. Delaware's expertise favors nuanced derivative analysis, and artificial intelligence from discovery could help. It helps organize evidence to show that there's no dispute, and it can more clearly show timelines proving knowledge. All of this reduces the cost of litigation, at least in theory, although on the other hand, we're producing more information, so it's not quite clear where the cost of litigation is going. Let me offer a hypothetical for a motion to dismiss in a direct suit. You're a shareholder and you sue over a false earnings report. So you plead that the statement made has internal contradictions, and you show that you lost money because you bought stock based on this statement and the stock price went down after the truth between the statement and reality came out. The defense will move to dismiss, saying there's no particularity or saying that there's no scienter, no intentionality between those statements. Might have just been a careless mistake and not a reckless one. But you need to show facts of recklessness, like ignoring warnings or red flags, and that might help you survive a motion to dismiss. Otherwise, the case is tossed and you never get to discovery. For summary judgment in a derivative case, after discovery, the defense will probably move saying that the evidence shows reasonable care and there's no breach. If the judge determines that the board took care, that is enough under the business judgment rule for the case to end at that point. Now, the plaintiff might counter with emails of ignored risks or a very short meeting or expert testimony showing that whatever was done doesn't meet the standard of care, but that only shows that there is a material dispute. So the game is whether or not you can show there is a dispute of material facts on the substantive claim. An example of a partial summary judgment is that the judge could grant a summary judgment on a loyalty claim but deny it on a care claim, narrowing the case, or vice versa. Pretrial motions are a chance to win early or force settlement, because once the case is narrowed, there might be less difference between how the parties see the case proceeding. And once they have some agreement on their chances of winning, we have a higher likelihood that they should agree on what the reasonable value of a settlement would be. In our next episode, we'll explore the role of the Special Litigation Committee in derivative litigation. That's a critical component which is going to generate the kind of evidence that we'd actually use in determining whether or not we can resolve a case at summary judgment. So we're going to come back to this idea of special litigation committees next, but until then, this is Seth C. Oranburg, and this has been Organized.